You'll just email the attachments to the clerk. Good morning. You're Ray No?
Good morning, ma'am. Yes, ma'am.
And will your client waive the formal reading of the indictment in each case?
He does.
Just a second. Figure out what today is. Sorry, I'm getting there. Mr. No, in cause number 25, DCCR 0386, you're charged with the second-degree felony offense of intoxication manslaughter with a vehicle from December 11th of 2024. And how do you plead to that charge?
Guilty.
And y'all have marked here aggravated. What is?
Defense counsel put that here.
Yeah, well, they charge it as aggravated with a vehicle, I believe. It was aggravating.
It's just a garden variety intox.
Yeah, I'm going to mark that out because I think that might have some
Different context.
context at sentencing that you may not want. All right, so it's how do you plead to that charge?
Guilty.
And are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
You're sorry it's going to be a trial.
Sorry, give me just a second to get to the other one. And then in cause number 25, DCCR 0387, you're charged with the state jail felony offense of driving while intoxicated with a child passenger from December 11th of 2024. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, Your Honor.
And are you pleading guilty because you did what they've charged you with?
Yes, Your Honor.
In each of those cases, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Franklin?
Yes, Your Honor.
Do you fully understand them?
Yes, Your Honor.
And do you understand that it's first of all, it's the way this is written up is that you are pleading open to the court. There's no agreement. Is that correct?
Yes, Your Honor.
And so you guys, a couple things. I need the other one sent back. So is it on the trial court certification of defendant's right to appeal? On this case, the state jail, the admonishments were signed saying that they're waiving the right to appeal. And then on the certification, it's actually 2 of them were checked off. One is the defendant has waived the right of appeal, and the other is it's not a plea agreement and the defendant has a right to appeal.
It's not a plea agreement,
Right.
so that's correct.
Okay, so with everyone's permission, then I'm going to erase the check mark on the defendant has waived the right of appeal because it's not a plea, so he will have some right to appeal.
Yes, Your Honor.
No objection.
Also, on each of the paperworks on the post-conviction waivers that you both signed, I will mark that out as well because that's saying that he's waiving his right to appeal.
Yes, Your Honor.
No
Okay,
objection.
all right, thanks. So,
Your Honor, I would note too, I think I had a few stray, I'm a left-hander. I think there's a few other stray marks on there that
Okay.
I tried to erase and wasn't able to.
Gotcha.
So if you see those, I apologize.
gotcha. We understand the left-handed issues up here. Ms. Werner feels your pain on that. Okay, so I want to make sure you understand a couple of things. You have an absolute right to have a jury come in and determine 2 things in these cases. The first would be to determine if you're guilty or not, and then the second would be if they find you guilty, you could leave your punishment up to that jury. If we go forward this way, you're waiving that right and you're leaving your punishment up to me in each of these cases, and is that what you want to do?
Yes, Your Honor. It's-
All right, state tenders number 1 in each case.
No objection, Your Honor.
It's admitted. Also, sir, do you understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, Your Honor.
All right. Is there any evidence that Mr. No is not competent?
No, Your Honor.
All right, sir. In each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of those pleas, find sufficient evidence to find you guilty. However, I'm going to reset your cases for a sentencing hearing so that the probation department can do a pre-sentence report. That'll give me more information about you, your cases, and then we'll come back later for sentencing. Obviously, if there's anything important that you want me to know, get that information to Mr. Franklin. He will present it to me on your behalf when we come back. Do you guys anticipate a little bit of extra time on this one as far as witnesses or argument,
Just brief, not much.
but a little more than normal?
Yes, Your Honor.
Okay, so if I were to set it at 11 on a docket date, we could, maybe an hour would be enough? Or do you
Yes,
think
Your
we
Honor. I
need
think
some?
an hour.
Okay, all right, so we'll reset it for sentencing and we'll just do it at the end of a docket so you don't have to sit and wait unless you have some other cases. You need to stop and talk to probation on your way out of the courtroom and she's sitting at that desk right over there. All right, we'll see y'all back at sentencing. Thank you.
Thank you, Judge.
On Mr. Boyd?
On board, yes, ma'am.
Okay. Is it
It's a
a?
rejection.
Okay. Good morning, sir. Are you David Alexander Boyd?
Yes, ma'am.
And Mr. Boyd, in cause number 25, DCCR 0720, you're charged with the third-degree felony offense of deadly conduct, discharging a firearm from March 20th of 2025. And what that means, sir, is that if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 10 years in prison. Do you understand?
Yes, Your Honor.
And I'm going to get a plea bargain rejection. What is the offer?
The state's offering 10 years, probated for 10 years with a $2,500 fine, standard conditions and no contact with a couple of complainants, as well as stay away from the Little Woodrow's establishment.
Sir,
Yes.
spit whatever is in your mouth out in that trash can over there.
Sorry, Your Honor.
So you've signed a plea bargain rejection with your attorney, Mr. Jeffries, and it's going to show 10 over 10, right?
That's right, Judge.
So it's for, if you wanted to enter a plea of guilty for a 10-year term in prison, that would be probated. You'd be on probation for 10 years. You would be ordered to pay a $2,500 fine to follow all of the rules and conditions of probation. You have every right to reject that and have your case set for trial. I want to make sure you understand today what your options are if you wanted to plead guilty and what your possible consequences are if you go to trial and are found guilty. Do you understand all of that?
Yes, Your Honor.
And do you want to reject that offer and have your case set for trial?
Yes, Your Honor.
All right, we'll get it set for trial. Mr. Coleman, is there any reason to believe that that offer would change?
Not at all, Judge.
So, Mr. Boyd, I want to make sure you understand that after today, I don't accept plea agreements once they're rejected. So unless new information comes to light with your attorney or the district attorney's office, then if you change your mind later and want to enter a plea of guilty, it would be to something different than this or open to the court. Do you understand?
Yes, Your Honor.
All right, then we'll get your case set for trial and Mr. Jeffries will begin preparation. And if y'all will just send that through, I'll
Just see.
sign off on it. Okay, perfect. You're free to go, sir.
Thank you, ma'am.
Larry Fletcher. Good morning. You're Larry Fletcher.
Yes, ma'am.
And Mr. Fletcher has 3 cases. He has a motion to revoke his probation, and then 2 new cases, cause numbers 25 DCCR 0839, a manslaughter case, and 25 DCCR 0838, an assault, aggravated assault with a deadly weapon. And what is the, so there was we were here at one point, and he entered pleas of not true in the motion to revoke probation, and it was, I guess, kind of reset for sentencing. But with those new cases, what?
Your Honor, with the court's permission, the state would like to proceed on the MTRP first.
Judge Matt, if we're gonna do that, I'd ask the court for 2 weeks. to do
No,
that.
we're not doing that today. I mean, because
No, okay, I'm sorry.
no, I'm not inclined, so, okay, here's the thing. Typically, the way I'll handle motion to revoke in new cases, if the new cases are, I don't want to have to hear it all twice. So if it's a new case and it's a witness or two, that's one thing, especially if it's a lesser offense. With these types of offenses, would typically be more inclined to hold the motion while we take care of the other cases.
The state's thinking, Judge, is depending on the outcome of the MTRP, I think that would be dispositive, potentially, of the other cases, without the necessity of having to pick a jury and go through the jury trial. But that's just the state's preference, Judge. I
Right.
understand the court's decision.
No, and I'm not saying I'm opposed to it, I'm trying to, so this underlying offense that he's on probation for is a second-degree felony. So what would it would be proving up the aggravated assault and the criminally negligent homicide?
That's part of it, yes, ma'am.
Time frame on that type of hearing?
Wouldn't be extensive, Judge. No more than a day. No more than a day. That's probably at the high end.
Okay. All right, so he's already entered the pleas of not true. So I'm going to kind of grant what Mr. Coleman is requesting on this one.
If it's essentially, and I'm not complaining about it, Mr. Coleman has the right to do whatever he wants here, but if it's essentially going to be miniature trials, then I would ask the court for some time.
Sure. No, so what I'm going to do is reset it for sentencing. Obviously, I need to find a day. Probably going to be 45 to 60 days out. Obviously, I know that might be quick to get ready for a trial, but I think you should already have
We're working through the discovery. Yes.
Is there anything you're waiting on, anything that's pending, outstanding?
Yeah, I'm not aware of it, but he's saying no, so then.
So because we're going to do it this way, let's do about 60 days, and then we'll look and find a day on a week where we do not have a trial, and I'll give you guys at least a day. On those weeks, we can even have a little bit more. All right? Okay, we'll see you back. Good morning. Are you Dale Johnson? And this was the final reset on Ms. Johnson's 3 cases. And so what is the announcement?
Regrettably, Judge, the defense announcement this morning is not ready. Despite our diligent efforts and the efforts of our expert, who is based out of town, our expert has experienced some health issues that have prevented him from completing his analysis and the report that we need to responsibly rely upon. And we are requesting one short reset to allow our expert to complete his work and his report.
Well, we talked about this last time, and so here's what we're going to do. If I'm looking back, so it looks like you were hired back in August of 2024. So what you need to do today is a rejection of any plea offer. If anything changes between now and the trial date based on that report, as soon as you get the report, you let the court and Mr. Hoffpower know. If there's some change, then I would consider accepting whatever the offer has been. Typically, I don't after there's a rejection, but because of the circumstances, it's time to get this case moved one way or the other. So I'm going to go ahead and get that rejection done today.
Okay, Judge.
It's on the tablet, and then it'll go on the trial docket. And again, As soon as you get that, if something changes, let me know. Otherwise, be ready for trial at the next trial date. You can let Mr. Hoffbauer know that as well.
Thank you, Judge.
I'll hold it while y'all do that paperwork, and then I'll recall it.
Thanks, Judge.
Yes, sir. Says Mr.
And there it is, a courtroom frozen in consequence, where every word carries weight and every pause echoes louder than sound. Guilty pleas are entered, offers are rejected, and time itself slows down as justice takes its careful steps. Nothing here is rushed, nothing is accidental, because real lives sit behind these case numbers. Choices are made knowing they cannot be undone, futures balanced on a single ruling. And when the room finally goes quiet, one truth remains clear. Justice isn't just about what happens today, it's about what follows tomorrow, and who must live with it.